Congress passed a law with overwhelming support to finally force public disclosure of the Epstein files. The Epstein Files Transparency Act passed the House of Representatives 427-1 and passed the Senate with unanimous consent. It gave the Department of Justice a simple 30-day deadline to release almost every unclassified record related to Jeffrey Epstein. That deadline was December 19th, and the deadline came and went. So what did the public get instead? A partial release with thousands of pages heavily blacked out. The DOJ announced it would release the rest on a rolling basis over the coming weeks, a delay that the law does not appear to permit. So what happens when the very Department of Justice in charge of enforcing the law violates it? Normally there are consequences for violating a law, but what if the law that was supposed to finally deliver transparency has a flaw, an enforcement gap that makes immediate consequences unlikely? This story isn't just about what the DOJ did, it's about what the law doesn't do. And in this video, we're breaking down the enforcement gap that's letting this happen and the battles that may come if Congress and the public don't believe DOJ has complied. To really get how complicated this is, you need to understand just how big of a promise was made by the new law. For years, survivors and the public have demanded answers about the full scale of Jeffrey Epstein's sex trafficking network and why Epstein received an unusually favorable resolution in 2008. The Epstein Files Transparency Act, signed into law on November 19th, was meant to be a major step toward a public accounting. The law was direct. It ordered the Attorney General to publish all unclassified records on Epstein in a searchable, downloadable format within 30 days. This wasn't a suggestion, it was a mandate. The scope was massive, covering everything from FBI agent notes and witness interviews to internal memos about immunity deals, flight logs, and all materials related to his longtime companion, Ghislaine Maxwell. Crucially, the act was designed to ensure transparency, including identifying individuals connected to Epstein's crimes and any entities tied to his financial or trafficking operations. To prevent a cover-up, the law has a powerful rule. It explicitly says no record can be hidden or redacted because of embarrassment, reputational harm, or political sensitivity. That clause was put there specifically to make sure the names of powerful people, no matter who they were, wouldn't be protected. The law did allow for a few narrow exceptions, mainly to protect victim identities, avoid releasing child abuse materials, or to safeguard genuinely classified information and active investigations. But for everything else, the order was crystal clear. Release it all. On top of the public release, the law requires a second layer of accountability. It requires the DOJ to give a report to the House and Senate Judiciary Committees just 15 days after the release. That report has to justify every single redaction and, this is key, provide Congress with a completely unredacted list of all government officials and politically exposed people named in the files. The law set the stage for total transparency, and the promise was written into the law with a rare, overwhelming bipartisan consensus. And then, the deadline hit. On December 19th, the Department of Justice did not release the full library of files as required. Instead, Todd Blanche announced they would only provide a partial release, with hundreds of thousands more documents coming over the next few weeks. This rolling release appears to violate the 30-day deadline in the law. What did come out was, for many, not sufficient. News outlets quickly reported that hundreds of pages were entirely blacked out. One 119-page document from a New York grand jury was released as a completely redacted block of black ink. The move drew swift bipartisan criticism. The lawmakers who championed the bill, Representatives Ro Khanna and Thomas Massie, publicly criticized the Justice Department for failing to comply both with the letter and the spirit of the law. Representative Khanna even warned that consequences could include holding officials in contempt of Congress, recommending them for prosecution, or even impeachment. The DOJ's reason for the delay in the redactions? The massive volume of material and the need to review every page to protect the privacy of over 1,000 identified victims. While protecting victims is a valid reason for redactions under the law, the scale of the blackouts raised red flags, especially since judges had already approved the release of some of these files with victim information protected. The DOJ publicly claimed it was not redacting politicians' names unless they were also victims, but the missed deadline and heavily censored documents led to bipartisan criticism. Everyone was left asking the same question. If the Department of Justice is violating a federal law, what happens now? That brings us to the central problem of this seemingly never-ending saga. Here's the question. What's the penalty for the Department of Justice for missing the 30-day deadline in the Epstein Files Transparency Act? The answer is the Act itself doesn't have one. This is the critical flaw, what some are calling a legal loophole, but is really an enforcement gap. The law created a clear legal duty for the DOJ to act, but it didn't include a specific penalty or fine in its own text for failing to do so. It doesn't give the DOJ a license to hide the files, but it means holding them accountable isn't as simple as charging them under this specific law. Think of it this way. A town might have a rule that you must shovel your sidewalk within 24 hours of a snowstorm. But if that rule doesn't also say that the penalty for not doing it is a $100 fine, the town can't just hand out tickets. They have to use other, broader legal tools to force you to comply, which takes a lot more time and effort. That's exactly the spot Congress and the American public are in now. The law created the obligation, but because it lacks its own teeth, the fight to enforce it moves into more complicated and challenging legal territory. It shifts the burden onto Congress and the courts, forcing them to use older, slower, and more politically sensitive tools to hold the executive branch accountable. This isn't some secret loophole the DOJ found. It's a missing enforcement clause that has turned a clear-cut deadline into the potential start of a protracted legal and political battle. So if the Act itself has no teeth, what are the legal battles that could actually force the government to release the files? Are we just stuck? Not exactly. The absence of a penalty in the Act doesn't mean the DOJ can't be held accountable. It just means the fight gets a lot harder. There are three primary, though difficult, paths if the disclosure is deemed unsatisfactory. First, through the courts, Congress or even outside groups can file a lawsuit seeking what's called a writ of mandamus. That's a legal term for a court order that compels a government official to do their legally required job. In this case, release the files as the law demands. If a federal court issues that order and the Attorney General still refuses, the court could hold those officials in contempt. Contempt sanctions are serious and can range from escalating daily fines to, in rare cases, even jail time. Not as punishment, but to coerce the official into following the order. The catch? It's a notoriously slow legal process. The second front is in Congress itself. This is the fastest path for political pressure. The House and Senate Judiciary Committees have oversight power and can subpoena the unredacted documents and the officials themselves to testify. If the DOJ defies that subpoena, Congress can vote to hold them in contempt of Congress. Or Congress could sue in civil court to enforce the subpoena. And as we've heard, some lawmakers have already threatened impeachment proceedings against the officials who haven't complied with the law. The Epstein Files Transparency Act was meant to be a floodlight, but the DOJ is considering it more like a dimmer switch. The fight for the full truth about Jeffrey Epstein and his powerful network may now shift from a simple deadline to a complex, uphill battle that will be fought in courtrooms and the halls of Congress. Accountability is still possible, but it's far from guaranteed. It all comes down to sustained legal pressure, congressional spine, and a public that refuses to take no for an answer.